Donald Trump blasts Crazy Eyes Griswold, and the ballot removal team at the Supreme Court of the United States were getting ready for oral arguments. And you remember the secretary from Colorado, Jena, she's going to be arguing in front of the Supreme Court. She's got a full 10 minutes. Her team is going to be there. Maybe she'll speak. Maybe someone else will. I don't know. But here on February 2nd, SCOTUS said, in anticipation of this argument over whether Trump is going to be removed from the ballot in 2024, that the Supreme Court's going to decide any minute, they said that Crazy Eyes is now getting 10 minutes. Granted, a total of 80 minutes is allotted, 40 minutes for the petitioner, that's Trump, 30 minutes for Colorado, and 10 minutes for Crazy Eyes Griswold out of Colorado. So she's going to be there to talk about this. But remember, they're trying to throw Trump off the ballot. They said that he's an insurrectionist. The 14th Amendment applies. They had a little fake hearing in Colorado. The Supreme Court of Colorado, 7 Democrats, all threw him off the ballot. In my opinion, they shopped the forum. They shopped the courts. This was their number one target. They got it done. Trump is appealing this to stay on the ballots. They say they're saving American democracy by throwing him off, but Trump is challenging this, and this is his final reply before the oral argument starts. So we're going to go through that, see what's inside, and see what Congress says, because Matt Gaetz and Elise Stefanik have submitted a resolution saying that Trump is not an insurrectionist, and they're saying we should officially rule on that in Congress. But here is what Jena Griswold, Crazy Eyes, before we read her what was said in response to her attempts, this is what she said when she was out in the media. And what's funny about this one is that she posted this one for us to see. She's very excited about her position and her role as the person who's saving American democracy by keeping people off the ballot. She posted this on her X account, and here's what she sounds like.
So, Secretary Griswold, just to be clear, you've been very careful on this issue. You didn't just come out and pound the table on this from the beginning. You know, for months, even on this show, you did stop short of saying Trump should be kept off your state's ballot, even though you did believe he incited an insurrection on January 6th. So you don't come to taking this stand and going before the Supreme Court lightly. Why? How did this happen that you've decided now to take a different and very clear public stand?
Like you said, I've always believed that Trump incited the insurrection. But it was pretty clear that regardless of my personal thoughts, the court was going to decide, did his actions reach the level of disqualification under Section 3 of the 14th Amendment? And a court has. The Colorado Supreme Court looked at all the district court's findings, spent specialized amount of time, and determined he did engage in insurrection. And that on top of that, the Constitution applies to the president. There's no get out of jail free card for insurrection for Donald Trump. And honestly, Aaron, I think they got it right. And I'm making this clear statement in protection of Colorado law because I think that's how the Constitution should work. Section 3 of the 14th Amendment is there to protect the country from insurrectionists like Donald Trump. And I hope that the United States Supreme Court looks at all the facts, all the case law, and the clear words of the United States Constitution in making their determination.
Yeah, we have the 14th Amendment. The insurrection clause doesn't apply to the president, but that's easy for most people to read. It's just in there. It just says that, right? It skips right over that position. But that's the person, okay? Regardless of what happens at the Supreme Court, she's going to be running the election. She's the Secretary of State, and she's not alone, okay? She's just a caricature of many of the other secretaries who are out there in all the various states, like Shenna Bellows in Maine and Jocelyn Benson in Michigan. They're the people, like maybe we don't care about Maine, okay? Maybe we're going to lose Maine. It's going to go blue. Maybe Colorado goes blue. What about Michigan? Maybe there's, a play for Michigan, and we got Jocelyn Benson there. All right. So you see it's a problem regardless of their dilapidated logic about the actual foundation of their claim. They're also going to be in charge of running the numbers. They're keeping score. They're the scorekeepers for the next election. And this is how they talk on MSNBC. So she's going to be in front of the Supreme Court at some point, and this is what Trump submitted as his final reply before the oral arguments start. In the Supreme Court of the United States, Donald Trump versus the ballot removal people, the people trying to throw him off the 2024 election ballots. This is Trump's final reply. Remember, he submitted his petition. The Colorado litigants, the people trying to get him off, they responded, and now Trump submitted his reply. It's in front of the Supreme Court. Oral arguments scheduled for Thursday. They write, in reply, in the Supreme Court, dear judges, Trump's team says, all right, SCOTUS, President Trump won the Iowa caucuses, in case you missed it, with the largest margin ever for a non-incumbent. And then he won the New Hampshire primary with the most votes of any candidate from either party. He is the presumptive Republican nominee, and he's the leading candidate for president of the United States. Even MSNBC's admitting the polls are bad for Joe. And they say, in our system of government, of the people, by the people, and for the people, the American people, not the courts or election officials like Griswold, should choose the next president of the United States. And as this court has explained, the right to vote freely for the candidate of one's choice is the essence of a democratic society, and any restrictions on that right strike directly at the heart of representative government. So they want to call Trump an insurrectionist. Trump never tried to remove anybody off the ballots, yet at a time when the United States, and this is official policy, Biden is threatening sanctions, literally, against the socialist dictatorship in Venezuela because they're excluding the leading opposition candidate for president from the ballot, footnote 2. Karine Jean-Pierre, she even had a press briefing about this. U.S. government pulls some of Venezuela's sanctions relief after the court blocks an opposition candidate. Okay, a court threw out a Venezuelan candidate. United States reimposes some sanctions. We do it here. They say we're saving America. Respondents, the litigants, they ask this court to do the same thing. Now, to date, at least 60 state and federal courts throughout the country have refused to remove Trump from the ballot. The Colorado Supreme Court is the lone outlier, and this court should reverse it. And for reasons below, and to protect the rights of millions of Americans who want to vote for Trump, you should throw this case out. Now, they get into this main argument that we've seen a lot about, talked a lot about here. Is the president an officer of the United States? And this is what Section 3 says. There are lists there, officers and offices. Neither of the lists expressly mentions the president. Now, the Colorado litigants would have us believe that the president is tacitly subsumed within a generic catch-all phrase called, quote, officer of the United States, an office under the United States. But she cannot overcome the overwhelming, talking about crazy eyes, the overwhelming textual and structural evidence that, quote, officer of the United States as used throughout the Constitution refers only to appointed and not to elected officials. And Crazy Eyes' arguments that the presidency qualifies as an office also fails to persuade us. Now, Anderson, the litigant, insists that every person who holds a federal office is an officer of the United States. Every single person. But that is wrong because the Speaker of the House and the President pro tem of the Senate are officers and hold federal offices, yet they cannot be officers of the United States. Why? Because they're not subject to impeachment and they're not commissioned by the president. Now, unless Anderson is prepared to throw out those cases and subject them to impeachment, because the other cases said that they're not, then she must concede that the officers of the United States refers to only a subset of federal office holders. And the only sensible construction of that phrase in light of the appointments clause, the commissions clause, and the impeachment clause is that, quote, officers of the United States, officers refers to appointed federal officials, and it excludes other officials like Speaker, President pro tem, President, and Vice President. Now, Colorado, the litigants, they reiterate their claims that Section 3 establishes a symmetry in pairing barred offices with excluding individuals. That's also wrong. 1, members of Congress, in quotes, it sweeps more broadly than senator or representative in Congress. Member of Congress is more broad. Section 3 also prohibits disqualified individuals from serving in the Electoral College, and it doesn't disqualify former electors who engaged in insurrection. And 3, the canons of construction, okay, how the statute was written, how the 14th Amendment was crafted, counsel against giving equivalent meanings to differently phrased provisions. So just don't say it's close enough so it counts. Now, the Colorado people don't deny any of this, but Griswold tries to get around these admitted asymmetries by observing that the electors and non-voting members of Congress are not constitutionally required to swear oaths, but non-voting delegates have always sworn an oath, even though the article doesn't require it. And Section 3, under the 14th Amendment, turns on whether an oath was previously taken, not on whether it was constitutionally compelled, right? So some very detailed nuance there. So Anderson cannot establish the symmetry that she insists upon, and so there's no basis for demanding correspondence between officers and office. So it's just, she's making it up. But then she tries to get traction. She can't figure it out in the Constitution. So she tries to step outside of the Constitution, and she tries to use the word officer in the colloquial sense of the word. But none of this purports to interpretate what the Constitution actually says, and none of it can alter or affect the constitutional meaning of the phrase. President Johnson cannot make the president into a constitutional officer because he described himself that way. I'm kind of an officer. That doesn't make him an officer. Any more than Congress can change the meaning of the 14th Amendment by enacting a statute. And no proclamation or floor statement or court opinion can override the fact that elected officials, including the president, cannot be characterized as an officer of the United States for 3 reasons. 1, they're not commissioned by the president. The president doesn't commission himself. They're not appointed pursuant to Article 2, as the Constitution requires, and they are excluded from civil officers described in the impeachment clause. Now, they try to get around addressing this. They get around to addressing it, and when they do that, they claim that the commissions clause means only that the president alone has the power to grant commissions. But that's not what it says. The language says the president alone alone may commission the officers of the United States. It says that the president shall commission all the officers, okay? It doesn't say this, that the president may alone commission. That's not what it says. It says shall commission all, meaning all. Shall means must. All means everyone. That's what the words mean. And when the Constitution requires every officer of the United States to be commissioned by the president, that means anyone who is not constitutionally required to be commissioned by the president cannot be an officer of the United States. Now, Anderson tries to get around that also in the Appointments Clause. Anderson insists that this caveat refers only to appointments. So basically, they're trying to, knock out all of their responses, and they're replying to their responses, saying their interpretation here is wrong for many reasons. One, the president is not appointed by the Electoral College. There's no appointments there. He's elected, so it doesn't fit. And only an appointed and not an elected official can be an officer of the United States. There's prior Supreme Court case law for that. House and Senate members, for example, are elected rather than appointed, so they cannot qualify as officers of the United States. The Constitution also consistently describes the president as elected and not appointed, and he cannot be regarded as an officer for the same reason. But their stance is talking about the senators, talking about the Emoluments Clause. They argue if this court holds that presidents and vice presidents are appointed, then any senator who became president or vice president before the expiration of a 6-year term will have served in violation of the Constitution if the president or vice president's salary had increased under the Appointments Clause. So it created a logical inconsistency. It would also empower Congress to strategically disqualify sitting senators from the presidency by voting to increase their salaries, because the emoluments, right? They're going to commingle. Now, even if the president could somehow be described as appointed rather than an elected official, he still cannot be characterized as an officer. He doesn't receive a presidential commission. He is listed separately from civil officers in the Impeachment Clause. The Speaker of the House and the President pro tem of the Senate cannot be squeezed into an otherwise provided for caveat. They're pretty important positions. You can't just shove them into some category. And third, Anderson is also wrong to claim that our interpretation leaves the quote otherwise provided for caveat without any work to do. The Constitution does provide for appointments of inferior officers. Anderson also claims that the Impeachment Clause lists the president and the vice president separately to avoid confusion, but this does not explain why the Impeachment Clause omits the word other before civil officers of the United States. They say that Anderson says that Trump's interpretation of quote officers of the United States will exempt the president from the oath requirement, but the first Congress enacted legislation requiring the president to swear the same oath as everyone else listed in Article 6, and a statutory oath requirement can reach beyond those mentioned in Article 6. So the absence of an explicit oath requirement for the VP doesn't make him an officer. It's also hard to accept the Colorado litigants, their construction of officer of the United States, when Section 3 only covers those who swear an oath to support the Constitution. So this is the oath, right? The officer's oath versus the presidential oath. Officer's oath says support the Constitution. Presidential oath says preserve, protect, and defend. They're just saying, well, it's kind of the same thing. They kind of mean the same thing, so one is interchangeable with the other. But then she needs to explain why the drafters of Section 3 would create this ambiguity by using the word support and exclude any reference to the presidential oath. So the 14th matches the officer's oath, not the presidential oath. If they said the president needed to be included in there, shouldn't the oath match the presidential oath? They had it match the category that they wanted to apply it to. They say Anderson is also wrong to say that Trump's interpretation defies common sense, they say. It was entirely sensible for Section 3 to exclude the president as a covered officer. Why? No ex-president supported the Confederacy except John Tyler, and John Tyler died in 1862 at the time of the war. Each of our 46 presidents except George Washington and Donald Trump would be covered by Section 3 because they held a previous job listed in the amendment. So each of them would be covered except George Washington and Donald Trump. Interesting comparison. That's an interesting fact. Isn't that interesting? Only George Washington and Donald Trump. Isn't that interesting? Interesting fact that they both have this in common. And former presidents, they have in common that they never held a prior job, would be covered by Section 3 because they held a senator or something else. Interesting. Trump and George Washington. Man, the liberals probably hate that one. And 3, former presidents rarely seek election or appointment to office. An overwhelming majority retire from public service. So indeed, Anderson's construction of a Section 3 will allow the courts, if you listen to them, to eject a sitting president from office. Now, apart from the impeachment process, if a court independently determines that he has engaged in insurrection, even if Congress refuses to impeach and convict on that ground. And so finally, they don't even mention this very important case. And that case makes clear the president is not an officer of the United States. They tried to describe the presidency as an office, but that's wrong. Anderson's construction of the word office under the United States is wrong. The Speaker of the House and the Senate are officers who hold federal offices, but neither holds an office under the United States because the incompatibility clause bars the House and the Senate from holding such an office, right? It's all technical distinctions here. Now, Anderson says it's clear, and you're not supposed to use that word in legal writing. If it's clear, then explain it. Don't use the word. That office under the United States includes the presidency. It almost means that your arguments are going to fail. Absolutely clear. Just explain it. But the evidence is far from clear. The most troublesome evidence for Anderson, Section 3 doesn't even mention the presidency. It's not even listed in the covered offices, but it does specifically enumerate senators, representatives, electors for president and vice president. But it excludes the president. Weird. And a draft of Section 3 that was introduced by representative called Samuel McKee explicitly listed the presidency and the vice presidency. So first draft says president. Then they deleted it. Yet this was rejected in favor of the enacted language, which omits any mention of the presidency. And instead, right, we're not talking about the president. We're disqualifying the individuals from serving as electors, right? The people who would elect the president. If you've got a question about their loyalties and whether they swore an oath or not, then they've got to go. So that's a mechanism by which they can protect against insurrectionists under the 14th, back during an actual civil war that lasted years, resulted in hundreds of thousands dead, not 4 hours. Then that would give you some protection against insurrectionists usurping that role. And they put that in there for a reason. That's the safeguard. So the Colorado Supreme Court tried to explain this, why they put that in there. They said, well, senators and representatives and electors do not hold offices under the United States, and therefore they needed to be separately enumerated. But it was at least debatable whether that phrase would encompass the presidency, especially when the phrase officers of the United States excludes the president every time it appears in the Constitution. So one would expect the text would mention the presidency if it overcame that other default. And they also tell us this is pretty obvious. Anderson claims that the events of the Capitol were an insurrection and that Trump engaged in an insurrection by supposedly inciting the crowd. Inciting the crowd, right, was the insurrection. He just incited them. Okay. This is wrong on every count. There was no insurrection. Trump did not incite anything, and the president did not engage in anything that constitutes an insurrection. Now, first, and this is the basis for them keeping him off the ballot. First, the events of January 6th were not an insurrection, as they did not involve an organized attempt to overthrow or resist the U.S. government. And by the way, no one's been charged with insurrection. So if they thought that, which is on the books, there is a statute for that. They did prosecute the Proud Boys and the Oath Keepers, but that was for seditious conspiracy, not insurrection. Now, events of January 6th were not an insurrection. They lasted about 3 hours. Most participants were not acting on any plan. They acted on a spur of the moment. Few, if any, like a handful, carried firearms, like weird, no firearms. And their objectives were narrow. They were there to pressure Congress and the vice president to correct what they were after. They thought that there were fraudulent election returns. They wanted an investigation. And even Ted Cruz was there, like calling for this, not an insurrection. Now, second, Trump did not incite anything. So it wasn't an insurrection in the first place, but incitement, that doesn't apply either. He didn't incite anything. He told his supporters to fight like hell, march to the Capitol, take our country back. But even the district court acknowledged that language of this sort is prevalent everywhere. The president's statements are far less provocative and definitely falls short of incitement under Brandenburg. Anderson says Trump's tweet was a problem, but that tweet did not call for any action at all. It was also sent over an hour after disorder broke out. So how could he have incited something if they're upset about his tweets that came after? So the district court had to rely on Professor Seames, this is back in Colorado, some professor, to say that Trump communicates in coded language, right? It's like a dog whistle for you MAGA supporters out there. Trump says go peacefully and patriotically, and you just want to start burning things like it's a BLM summer of love. Except there were no third precincts of Minneapolis that were burnt to the ground, unlike their riots. And Kamala Harris was supporting them getting out of custody. So can we bail these people out who torched a police precinct? Remember all that? Trump, no, none of that happened, obviously. But it's coded language to push Trump's speech into the incitement category. And Anderson now tries to downplay the role of his testimony, but she has nothing apart from Seamy that can convert Trump's statement, which would be otherwise constitutional, if uttered by any person, now suddenly become criminal because it's incitement. And third, even if there had been incitement and insurrection, which there's not, Trump still did not engage in it. Incitement, which did not occur here, you can follow the bouncing ball, right? Because a person who incites seeks only to bring about imminent lawless action. Trump didn't want to do that at all. Not at all. Not all lawlessness rises to the level of insurrection. There are things called riots. And the district court found only that Trump's speech and tweets, they incited imminent lawless violence, not that they incited anything that's an insurrection. So even incitement of insurrection would not be enough to constitute engagement of insurrection, because incitement Incitement turns on whether a person's speech is directed towards or likely to produce, whereas engagement is actual participation. So it's an even higher standard. Now, Trump is not arguing that engagement requires personally committing the violent acts, but he's arguing that none of his actions, including his speeches, none of his social media posts, none of this qualifies as engagement in an insurrection. Now, none of the authorities cited by Anderson that include incitement as engagement involve speech or conduct of the sort that Trump is alleged to have committed here. And finally, the court should not apply the clearly erroneous standard to constitutional facts or mixed questions of law. Clearly erroneous, right? Saying that we're just going to defer, in other words, to the lower courts. And we're only going to overturn Colorado if we decide that it was clearly erroneous. Like, it's a high standard, right? We defer to the lower court rulings. We leave them settled if we can. They say that is important. That's the appropriate standard for basic. They say the district court's findings involving Trump's mens rea should be reviewed independently. Why? No witnesses claim to have firsthand knowledge of Trump's intent or thought process. It's all conjecture. The trial court is in no better position than this court to determine Trump's state of mind based on the evidence that was presented there. And lastly, Section 3 should only be enforced of the 14th Amendment through Congress. It's not self-executing. Trump is not arguing that Section 3 is non-self-executing. His claim is that Section 3 may be enforced only through congressionally enacted methods of enforcement. Now, the litigants from Colorado, they do not deny that congressional implementation can implicitly preclude other means of enforcing this. But regardless of what they think, the fact remains that it was only judicial decision in place. We don't like this case law, but it's the only case law that exists. Now, Anderson notes that the Insurrection Act, the only surviving piece of congressional legislation that was enacted before the 14th, sweeps more broadly than constitutional disqualification. And if we accepted their arguments and their interpretation, that means that Trump could not constitutionally serve as president after J6, right? Like after January 6th, that's it. It's self-executing and there's nothing we even need to talk about. It just happens. So he would have automatically been disqualified after the 6th. So they say Section 3 cannot be used to deny Trump access to the ballot. This is another interesting point. Anderson argues that Colorado can exclude Trump from the ballot if they conclude that he is presently disqualified. But that's not true. The law says it's about holding office. Anderson's stance is indistinguishable from some other cases, and they ignore these other requirements. None of the other rulings they're relying on would allow them to deny ballot access to candidates whose qualifications are contingent upon future action. So they're wrong to say that Trump is presently disqualified. Section 3 is a prohibition only on holding office, okay? So you can run for office. Congress can waive this prohibition. So no court or litigant can declare that Trump is presently disqualified from holding office. He hasn't won it yet. He's got to run and win. Anderson may believe or hope that Congress will not waive Section 3 between now and January 20th, but neither the Colorado Supreme Court nor this court can declare a candidate ineligible for the presidency now based on a prediction of what Congress might do in the future. And so finally, Anderson invokes the Electors Clause, but neither does this or anything support that they can alter their elections, saying the Colorado Supreme Court actually did violate the Electors Clause. Anderson makes no attempt to reconcile this other language, and so therefore, Trump's team says the judgment should be reversed in the state of Colorado, and Trump should be allowed to be on the ballot, which makes, logical sense if you live in a democratic republic. But Crazy Eyes Griswold and the 7 Democrats, they want to keep him off because they're concerned that he's going to win. And I think they're right about that. Their concerns are well-founded. I think he is going to win. But here is the final reply from Donald Trump to the Supreme Court. Oral arguments are scheduled on Thursday, February 8th, and we're going to be covering those here on the show after they are completed. But there's other actions in Congress. Matt Gaetz is saying, speaking about this insurrection problem, how about we just declare that Trump is not an insurrectionist? And here is what Matt Gaetz says in DC.
But we are here today to authoritatively express that President Trump did not commit an insurrection, and we believe Congress has a unique role in making that declaration. It's not the job of the states, and especially not the job of some bureaucrats in Colorado, to make this assessment and interfere with the rights of voters to cast their vote for the candidate of their choice. The very experts who often get on television and talk about securing democracy seem to be the first to want to then remove a candidate from the ballot because they are afraid that he is too popular. We have 63 co-sponsors to the resolution that Ms. Stefanik and I will be filing today to express the sense of Congress that President Trump did not commit an insurrection. I want to express my gratitude to Senator Vance for filing the companion legislation over in the Senate. And now is time for members of the House and Senate to show where they stand on this question. We and the former president welcome and expect many more co-sponsors in the coming days and look forward to a floor vote. And now I'd like to recognize recognize my co-lead on this project, our terrific Republican Conference Chair, Elise Stefanik.
All right, we're going to listen to her in a quick second, but it's an interesting thing, right? They're relying on Trump being impeached but not convicted as evidence. They're saying, well, he was impeached. A bunch of people in the House of Representatives, Congress did impeach him and say he did do something with an insurrection. And so they said that was kind of good enough. We saw that come up many times in the prior filings. So what happens if Congress comes back out and says, actually, no, there was no insurrection and that's congressionally dictated? I think that would be useful. My concern is, what if they don't get it done? What happens if they come back and they find that he was an insurrectionist via a resolution? What does that do? I don't know. I don't know that it does anything, to be perfectly honest, because my standard is impeachment and conviction. But this would, I think, create some gap for the domino effect. And I think it might actually stop some of the domino effect, because then they could say Congress has made this conclusion. All right, so that is what Matt Gaetz says. Now, here is Elise Stefanik. She came out and she added a little bit of meat to those bones. Here's what she says.
The American people are smart. They know that the weaponized attacks of radical far-left prosecutors and Joe Biden's Department of Justice against President Donald Trump are nothing more than a targeted political witch hunt used to further their own extreme far-left political agenda and hijack the will of the American people come Election Day. As President Donald Trump continues to dominate in the polls, extreme Democrats will stop at nothing in attempt to prevent President Donald Trump from returning to the White House, and the Democrats are shredding the Constitution in the process. Joe Biden claims that democracy is on the ballot, yet the American people know that it is Joe Biden and Democrats who are openly attacking democracy. I am honored to stand as an original co-sponsor on Congressman Gaetz' resolution that President Donald Trump did not engage in insurrectional rebellion against the United States. That is a fact. Rogue far-left Democrat operatives are attempting to use this lie to illegally take President Trump off the ballot. This week, the Supreme Court will begin arguments in Trump v. Anderson to determine if liberal activist judges have the right to erase Donald Trump from the ballot, steal the election, and the American people's right to elect our leaders. For the sake of American democracy, I am proud to fight for President Trump and the tens of millions of American patriots who face political persecution. With that, I'm honored to turn it over to Bill Posey, our colleague who is also a co-sponsor of this bill.
All right, so some action from Congress. We'll see if it, gets any steam behind it or if it matters. I think it would be a slim victory in the House. Obviously, the Senate's going to have a different opinion on that. J.D. Vance entered in a companion bill. Senate's not going to vote against that. So it's probably just a little bit some political gamesmanship, which is not necessarily a bad thing. I think that it's time for more of our congressional so-called leaders to pick a side on this, right? Are you okay with this Justice Department doing this? Are you okay with the courts doing this? Many of them ignored it. Many of them during the Republican primaries ignored it. We're not accepting that anymore. Time to make a decision. Do you stand with the corrupt DOJ or not? Elections are coming up. Make your voice heard. Stand up for something. And we'll see if Congress does that. Some of them did. Shout out to Matt Gaetz and Stefanik. So we'll see where it goes. My friends, we're going to be here continuing to cover this. The SCOTUS oral arguments are coming soon. We're going to see what happens with Crazy Eyes Griswold and the rest of litigation at the Supreme Court. Thank you for joining us as we do. Don't forget to subscribe and to like this video wherever it is you're watching this. We got a bunch of good links down in the description below. We've got watchyourlodge.com, amazing events in February. So make sure you go to watchyourlodge.com, check the community calendar, sign up for an event. They're free for the first 48 hours. So come and join us live before they go into the lodge archives. So come check it out. If you want to grab the PDF that we read through, robertgovea.com, also linked down in the description below. Grab yourself a hat, grab yourself some gear from the store, sign up for the daily newsletter, and we'll look forward to seeing you back here on the next one.